So we have video footage of the trial proceedings from both Steve Lawson's trial and also Brooks Houck and Joey Lawson. For the first time, the public is getting a look at not only these proceedings, but also some of the evidence that detectives and investigators have been talking about for 10 years, and we're finally getting to see up close. I want to start with the big moment, of course, the moment Judge Sims reads that guilty verdict.
And I have not seen these, so you're showing them to me right now for the first time.
Great.
In regard to Commonwealth versus Brooks William Houck, in regard to instruction number 4.
If you'll pause right here. As a lawyer, this is the worst moment in your job because you don't know what's about to happen. I mean, I will tell you, I've sat through 77 verdicts, I think, and I don't care if I had the best case in the world or I knew my client was going to get convicted of the worst case in the world. It is the most sickening feeling. I literally have to hold my hands like together because I'm usually shaking because it's just, even if you know what's going to happen, and sometimes the sheriffs will tip you off, it's still that, like, it literally is like, oh, I'm about to go up a 1,000-foot roller coaster and go straight down, or I'm going to jump out of a plane and parachute. Like that feeling of like, it's an adrenaline, nervous. If you can tell, all of their hands crossed, like everybody is sitting like, it's a very, even as a prosecutor, it was the same way. It's like very tense feeling.
So do you think for Shane Young, Brian Butler?
Oh my gosh, none of them have eaten breakfast. They're sick to their stomachs. Yes, absolutely. And it doesn't matter if and again, I've done it prosecutor side on big like murder cases, defense side on big murder cases, federal cases, even I've had stupid district court cases where a speeding ticket and I'm still like, shit, I don't know why. It's such an uneasy feeling and it doesn't go away. And I was told once a long time ago, the moment you don't feel that way anymore, you need to quit doing it. Because it means you're not emotionally and mentally invested, So.
Wow. So it never ends.
And to be fair, Jim Lisowski, he's right here. He is in his 41st year, which, by the way, I've tried a double homicide with him years ago, and we got convictions on that, murder convictions. He was a mentor to me. I can tell you, Jim's the same way. He has done this. He's probably tried 1,000 cases, and he is shaking in his boots still because he doesn't know what's going to happen.
Wow. So before we go on, I do want to point out, of course, this is the Commonwealth side, yes. The defense's side. You can see Sherry Ballard right there, a lot of the Ballard family. And then over in this corner, you can see Rhonda McElvoy. You can see Rosemary Houck right there. Just to sort of give a lay of the land, of course, Brooks Houck is in that blue button down, Joseph Lawson in that black suit all the way on that right-hand side. And I will continue.
The jury find the defendant guilty of murder, principal, or accomplice under instruction number 4C. And under instruction number 5, it says, we, the jury, find the defendant guilty of tampering with physical evidence under instruction number 5. In regard to Joseph Lawson, the verdict form number 4 says, we, the jury, find the defendant guilty of conspiracy to commit murder under instruction number 4A. And under verdict number 5, we, the jury, find the defendant guilty of tampering with physical evidence under instruction number 5.
Notice, though, that no one reacted generally. I mean, I tell my clients that you do not smile, you do not cry, stoic is always the word I use, and I always say that. And I always tell, when I was a prosecutor, I told families, I said, I know it's one of the most, if not the most emotional day of your life. You do not react. If there's ever been a time where you got to keep it in, that is the time. Because judges, doesn't matter what side, you start getting loud or upset, they will throw you out of the courtroom, hold people in contempt. It doesn't matter if it's a victim's family. And I get it. I had a homicide years ago that was gang-related. It was very tense on both sides, very, very tense. And a fight broke out in the courtroom right after the verdict was read. It was about, I think it was like 11 o'clock at night, and a complete brawl broke out. And luckily they were prepared. There were 15, 20 sheriffs in there. But still, it's a very, I mean, you were in the courtroom, it's a very tense moment. I mean, even the air could be on 60 in there and it feels like it's 200 degrees.
Right. I mean, even the media, there was tension.
Right.
Of course, those instructions to be stoic, to remain still for the clients, but what about the family members? Does that apply too?
Yes, I always say that to any family of anyone I represent. I say, I know that you're going to be upset, either tears of joy or tears of pain, and I've had moms and stuff, and I say, if there's an outburst, get out of the courtroom as fast as you can, because that is a quick way. A judge will not put up with it, and they can hold you in contempt, which is essentially fine you, put you in jail, or anything like that. So especially when you got that many people in a courtroom and it's this publicized, it can be such a tense situation, and you have families on both sides. I mean, the last thing they want is a fight to break out, right? Some riot in the courtroom. And so the judges generally, at least my experience in Kentucky, and that goes for all over, I've tried cases, do not put up with any from victim's family or defendant's family whatsoever.
So was this sort of the reaction you expected?
I was a little worried that there would be bad reactions from both sides, regardless of the verdict, or one side or the other, defendants' families or victims' families. But that being said, I think this was the appropriate reaction. No one screamed and yelled. So this was a well-controlled courtroom by the judge, by the sheriff's temperament. I mean, I think you can see their sheriffs all lined in there. So I think that presence too reinforces, hey, we're not going to put up with disrupting court proceedings,
There are a couple key moments in this video. I'm going to do a playback just so you can see. I want you to pay attention to Brian Butler, of course, the second man sitting at the defense counsel table.
Okay. In regard to Commonwealth versus Brooks William Houck, in regard to instruction number 4, it says, we, the jury, find the defendant guilty of murder, principal, or accomplice under instruction number 4.
So you see his head drop.
Yeah, I mean, that's just it's a gut-wrenching feeling when you lose. Whether your client is innocent or guilty, and it goes again for the prosecution if you lose, it just is kind of like, I put 2 years of my life into this, and it's just kind of like, well, nope, they did not believe what you were saying over the past 2 weeks and how many 80, 90 hours of testimony. So it's a rough feeling. It's not good. It does not feel well. And you start second-guessing yourself, and again, both sides, no matter what side you're on, when you lose a trial, especially when it's highly publicized, even when it's not, though, and when it's just a trial, especially though you deal with homicide trials, it is tense. I always say, like, people, if they want their black belt in practicing law, go try a murder trial. And that's the kind of the ultimate feeling of terms of stress with having to know the law, having to be able to react on your feet, having to be prepared, and also having to keep your emotions in check. I mean, he put his head down, but that's still, it's a rough feeling.
You're, of course, a former prosecutor as well. I want to know what you think is going through Shane Young's mind. If you could take a look at Shane Young right there, Teresa Young, some glances are exchanged and also some hand movements.
Okay. In regard to Commonwealth versus Brooks William Houck, in regard to instruction number 4, it says, we, the jury, find the defendant guilty of murder, principal, or accomplice under instruction number 4C.
I think that was a look at Sherry Ballard to say, we got him. Job, mission accomplished. Which I have done that when I was a prosecutor, especially on homicide cases, or I had a very victim intense case. Kind of, they know when you look back and just give a nod. It's just a glance, but yeah.
So what's that feeling like?
A relief, like, thank God, And again, it goes both ways though. When you're a defense lawyer, and if you get that not guilty verdict, it's like a thank you God. Like, I mean, it's a that's that feeling. But especially with a case where you put so much time in. I mean, obviously, the higher amount of effort you put into it, the more the feeling of relief. Because sometimes you get weird verdicts to where they split the baby. They say, like, they'll have lesser included. This one didn't really apply that way, but where those lesser included, and it's like, I've had verdicts to where the defense lawyer and I was a prosecutor, or vice versa. I've been a defense lawyer, look at the prosecutor, and we're like, what? That verdict makes no sense. You know what I mean? Like, we glanced at each other and going, how did they come up with manslaughter first degree? Or do you know what I mean? There's instructions to where the judge gives it and we think there's no way they're going to do this, and they do, and it's like that, look. But that's definitely a look at, I believe, probably from Shane to Sherry Ballard saying, we got him.
A lot of emotions. Of course, we can't see the jurors in this. We'll move on to the next major moment here. For 10 years, we have not seen moving video of Crystal Rogers. In testimony here, we see the final moments of Crystal Rogers as she's walking out of Walmart on July 3rd, 2015.
Right.
I'll play the video and then we can go through some questions.
Yeah, they're walking from their vehicle where they parked, and then that's the entrance camera. That's Crystal, the two children in the other two children in the eye. And I think that's them checking out. There were several other camera angles that just kind of fall into the story.
10 years, and it's the first time the public is seeing Crystal Rogers in video hours before her disappearance. How would this impact a jury?
I think it just humanizes her, makes them see that this is a real person. It's one thing to talk about somebody, but actually see them going about their daily lives like all of us do, right? Going to, I think it was Walmart, I believe. It certainly gives a more real feel to the proof presented. It's not just somebody in name, but it shows that's a human being that had value and meaning and a normal life like all of us.
And also, sort of tipping jurors off to one of those fascinating questions that we heard, were the clothing that she was wearing in Walmart ever found?
Right.
Really good question.
Yeah, no, I thought that was a great question too. I mean, this is hours before, right? What are we at, 3:46 p.m. on July 3rd of 2015? So, I mean, I think that was a very reasonable question to ask, certainly.
Anything else from this video that stands out to you? What impacts it would make in an argument on jurors? Do you think that this video essentially led to building that circumstantial case as it was intended to?
I think it gives a starting point to a timeline, right? Because this is where we know 7/3/2015, 3:46 p.m. Because you got to start somewhere, okay? And they don't want to start at, 7:24 p.m. when she's starting to play games on her phone or something. So this kind of gives a timeline that, if there was ever an argument she left Bardstown and was still alive, well, that's false. Here she is with her kids. She was involved in her kids' life. We see the kids following her in. So there's no question about it. It's good to kind of give a starting frame of reference for the jury to narrow down and say, hey, this is what we're talking about. Let's start here. We know this is hard proof. It's on the video, and then we'll move forward from there, which is what the prosecutor did.
And give credibility to that witness, Amanda Greenwell, who Crystal had run into during her trip to Walmart. So.
Absolutely, yeah, because clearly that's where she was. There's no doubt about that.
Our viewers have not seen what Charlie Girdley looks like, what he sounds like, what that testimony was like, even how the defense came in with that cross-examination, tried to poke holes in that theory. So we're going to show you Charlie Girdley, and we want to get your analysis on this as well.
At one time or another, I'm not real sure if it was that night or before or after, but he said he would shave their head and pull their teeth, and the Hogs would do the rest. Okay.
Was this a piece of evidence or a testimony that was new to you when you heard it?
Oh, absolutely. I mean, this is a piece of evidence that convicted Joseph Lawson, in my opinion. I mean, they really didn't present much else to tie Joseph Lawson directly in, and this was not only tied him in, but it's not pretty, it is very gory and upsetting, and something that it jolts you when you hear it. It's one of those things that I think the jury heard it was kind of, I assume, again, I'm not in the jury's mind, but I think it had to have struck a very, very deep chord with them Number one, because the shock value of it. Number two, if you notice when he says that, he's not yelling and screaming or acting crazy. Now, I know that cross-examination got intense with him, and they talked about his different stories, but he's kind of saying this very matter of fact. You know, Shane Young asked him the question, and he's just matter of fact saying, well, I mean, this is what he said. You know, and so I think that certainly was probably the reason why the jury wanted to watch it one more time, because remember, they had sat through tons of testimony, got this shock value. But it's one thing when you hear it, I think, you know, and sometimes, I don't want to say jurors fall asleep, but they get bored, right? You're going through run-of-the-mill, what's your background, where are you from? And jurors are like, okay, we've heard this 70 times, this person, we get to it, you know. And so when a trial goes on so long, sometimes juries do forget, even with their shock value stuff, but they did remember him, and they asked to rewatch specifically this portion of the video. And so I would say, at least based on that alone and based on what was presented against Joseph Lawson, this was probably the most damning piece of evidence that was presented by the prosecution against Mr. Lawson.
The evidence that elicited the strongest reaction from the Ballard family, of course, too. We could hear, you can't necessarily hear it in this video, but you can hear the Ballard family choke up over this. Even in an interview that we did after the verdict was read with Crystal Rogers' oldest daughter, she said that this was the hardest thing to hear in the courtroom.
Right.
When you're defense in this situation, what's going through your mind?
Oh crap. I got to do something about this. I got to tear this guy apart and make him look like a liar. I mean, that's the number one thing. When you don't have something to hard proof refute someone. So if somebody says, I was at bar A during X, Y, and Z time and I saw something. Well, actually you weren't, sir. Here's the video to show you weren't there. Okay, you're nowhere on this. When you don't have that, then your next available option is to either own it. Obviously, they don't want to do that. So the last option is, okay, I have to tear his credibility apart to make him look like a liar on every single thing he said, so the jury doesn't believe anything he says. And so that's kind of what the defense strategy was, I think, for both Butler and for Boyd here. But, you know, and they did a great job. Let's not forget that they did, on cross-examination, rip him apart. But at the end of the day, the jury believed what he said there.
And that cross-examination will play a bit right now, just so we can sort of analyze this approach of painting Charlie Girdley as both unreliable. And there was also elements here about police coercion.
Right,
he told a different story 6 times. So we'll play that clip for you too.
No question that you know that these detectives are investigating the disappearance of Crystal Rogers. You know that they suspect him, and everything that you said in your first response is not true. Is that correct?
Yes, sir.
And you did that under the circumstance you were under. You were under a lot of pressure, right?
Yes, sir.
That's, of course, Steve Shoring in cross-examination with Girdley.
So if you're and I said Butler on there, I'm sorry, I meant to say Shoring. Shoring did that cross-examination, Shoring and Boyd. Steve Shoring's strategy there is he wanted Girdley to fight with him, okay? He wanted to say, you said X, Y, and Z, and you were a liar, right? You're a liar. I mean, he didn't say it that directly, but that's what he's hinting at. But Girdley really owned it. Now, the way to take out a sting is when someone says, I did lie in there. I did. And they stay calm. Not, don't you call me a liar. You know, you want to get that reaction. You want to poke that bear so he bites back. And Girdley didn't bite back. And I think that, you know, that was a problem. Now, he did get a little cross with Boyd on the questions Boyd asked him. But if you look right here, this specific question, you know, Shoring wanted to get under his skin and basically said, you're a liar based on this first statement. And Girdley says, I did lie. You know, yes, I didn't tell the truth. Yes, I was under pressure, you know.
And truly being someone who was in the courtroom throughout his entire testimony, he really kept that demeanor throughout.
I mean, you saw it, and, you know, it's effective because you get these witnesses, especially on the defense, and you're thinking, okay, I'm gonna poke. If I can get them to just bite back at me once, then I can throw off their whole credibility. But that didn't really happen. And so I think that, that was harmful to the defense. Certainly he didn't have much credibility in terms of the stories he's told, but the difference is now we're looking at his demeanor. Okay, it's one thing to hear it and read a transcript, but it's another thing to see someone's demeanor. And watching his demeanor here, I mean, he stayed pretty calm.
What do you think the public watching this for the first time, of course, seeing the headlines, seeing the media report what Charlie Girdley has said throughout his testimony, what do you think is going through the public's mind if they were to watch this clip?
I think they'd say the same thing. Obviously the defense is trying to paint him as a liar, but he seems pretty calm under pressure there in a courtroom full of hundreds of people.
And of course, when the defense was arguing their case, they brought in Rhonda McElvoy, and she is Brooks Houck's sister, and she comes in to really foil this whole theory about the Hogs. We'll play the clip for you.
Ladies and gentlemen of the jury, heard testimony about hogs. I'm not going to get into this. Did you all have a hog farm at your mom's farm back in 2015?
We did not have a hog farm in 2015. What was there were some little pink pigs. They had some little black dots on them, and they were right. There was a little enclosure that my mom had in her backyard.
So she describes the pigs that were on the farm and includes a photo for evidence. What are your thoughts on that?
At first I thought, great move. Little bitty pigs. Then I spoke with a friend of mine who grew up on a farm, and I have a complete different reaction now. The reaction being, a friend of mine told me, hey, those little pigs, give them something, give them an hour, they will devour whatever. And so, this is being tried down in Bowling Green, right? And it is a city, but a lot of people still have farms around the area. I think if you have any jurors with experience with raising pigs or hogs, well, here pigs though, like the picture, they certainly would probably attest to the fact that give those little piggies about an hour and something will be gone. And so I do wonder if some of the jury, remember, jurors are allowed to use their own life experience, okay? Now, it's not evidence, but they're allowed to use their common sense and their life experience they had in life. And so, if any of them had that experience, they're going to say, those little pigs certainly could devour something relatively quickly.
Fascinating.
Yeah, and again, this is me just talking to people that I'm friends with, other attorneys and things like that. But, as one viewer said, I saw on a comment, he said, clearly you've never been around a bunch of little pigs before. And it's like, oh yeah, he is 100% accurate, at least based on the discussions I've had with someone that grew up on a farm.
And just the idea that jurors are critically thinking about this evidence, as you mentioned, using their life experiences. Of course, you have Rhonda here describing little pink pigs with black dots on them, but then you see the photo. Yeah,
they're not that little. And the other thing is, I said to Doug on the air when we first heard the testimony, why did nobody ask if there were pigs on the farm? That was the question. But now looking back, it's like, well, if I was the defense, hindsight's 20/20. So I'm not bashing the defense in this, but hindsight's 20/20. But looking back, I don't think I would have entered that photograph. I would have left it out there and said, members of the jury, the prosecution has not provided any evidence there were pigs or hogs on that farm whatsoever.
And leave it at that.
And left it at that. And you would have been correct, because they didn't, right? This was the defense that put this out there, not the prosecution. And so, but you got to go with what you believe and what you have at the time. And certainly, I think Girdley said hogs. Those were not hogs, they were little pigs. So really, it's a judgment call. Hindsight's 20/20. Everybody wants to be a Monday morning quarterback on trials, especially when you're defending someone. But a difficult call. They made the call to enter the picture, but looking back, it may not have been a great idea.
The hog theory has been hearsay around Bardstown for 10 years. How do you think all of these clips, all of these moments combined, what do you think would resonate most with the jury?
Well, certainly that would go to the theory we've heard around Bardstown, right? If you feed her to the hogs, then that's why her body would never be found. Of course there's not going to be any DNA. course there's no body. I mean, again, I'm speculating there. I'm not saying that's what happened, but it fits the theory of what we have.
And you think that could have been one of the most glaring pieces of evidence for the jury to hold on to?
It certainly, the fact that they watched Charlie Girdley's testimony a second time is very, very important. They did not ask to see any other evidence at all. None, if I recall. They just asked to see that. And so that specific, and they only asked to see that portion about talking about the feeding her to the hogs, pulling her teeth. About 10 minutes of that on the direct examination. So, you know, the fact that they asked to see that had to be huge.
I hear you. Another major moment that we heard, and we haven't talked about Joseph Lawson a ton, but in Robert Boyd's closing arguments, he creates this argument that the Lawsons are almost incapable of doing such a task. Mm-hmm. Play the clip for you.
Following up on his sophistication to believe any of the Commonwealth's theory, you have to reasonably believe that he would trust this incredibly important task of getting rid of the car to a father-son duo, one severely alcoholic, the other severely alcoholic with major drug issues. They couldn't even really get along to accomplish this task. It doesn't make any sense. When you're using your God-given common sense, think about that. I'm not saying Brooks had anyone move her car, but if he did, that sophisticated businessman did not hire these fools to do that.
That sophisticated businessman did not hire these fools to do it, and he points at Joseph Lawson. Mm-hmm. What stands out to you about that argument?
It's a good argument. I mean, it's a risk of saying, hey, this guy, if you're believing that he did this, why would he task someone with such a serious thing of moving a body, moving a car, tampering, whatever it may be, with two people who can't get along, complete drug addicts, alcoholics, have a clear issue with substance abuse, had been, I believe, drinking that night. I think at least Joseph Lawson had been the proof that he was at a bar earlier that night. Why would you leave that task to them? You know, it's certainly as someone who's built multiple neighborhoods, owns properties, has houses, and certainly had means to pay someone much more sophisticated who would, I assume the argument would be, do a better job to, you know, make sure there's no trace of anything. The flip side of that is, there is a flip side to the argument, which is, hey, of course he would pick these two, right? Because no one would suspect them. No one would suspect these two guys that kind of barely are making ends meet or terrible alcoholics. Nobody's going to bother them, and they may be scared of him. They may be scared of Houck because he has power. He's the one that pays their check. So of course they're not going to talk, and of course they're not going to go against him or go against his wishes. They're just going to keep their head down, do their job, and move on.
Evidence is evidence, right?
Right.
How important is it to characterize your clients when forming your arguments? I'm not talking about cell phone data or DNA testing or anything, but painting Brooks Houck as a sophisticated, well-off businessman, and painting the Lawsons as, Boyd even used a quote, on the fringes of society. How important is that characterization?
It's the first, they had, for the most part, been a team, okay? And this is the first time we're really seeing a separation. And I think that you as much as Boyd and Coleman were working with Schroering and Butler, it's a situation where at some point you got to put a little distance between you and the other party to say, look, you may convict him, but don't convict us. We're not together. Like, we're not, we may work together on this trial, but in terms of the facts and in terms of whether or not you're choosing to find Brooks Houck guilty of murder, leave us out of that. We're not a part of that. So I think this was an attempt to actually put that space, and it was probably the best way that he characterized it, to put that space without, because you want to be careful though, because sometimes if you as the attorney start pointing fingers at the other party, they're going to point fingers back in theirs. It was a way to not say Brooks Houck was guilty of murder, but still separate out and say, look, whatever's happening over there is happening. We're not a part of it. And certainly we know we're not a part of it because he wouldn't have hired us because we're fools and we're drunks, and we probably wouldn't have done a good job at it.
Fascinating. I get that theory. So you wouldn't want to sink the whole ship.
Correct.
But you want to distance
Exactly.
yourself because at the end of the day, it's your client you're representing.
Right. Yeah, you want to get on the little boat and let their ship sink. You don't want to be sinking with their ship. You got to be careful. It's a fine line to walk, especially when you don't. Because there are times though when defendants are antagonistic, okay, and they're like, no, he did it, she did it, he did it, she did, and the prosecutors love that. Okay, that's what they want, because you know what the prosecutor gets up and says in closing. They both did it. That's why they're pointing fingers. And, you know, that's why generally, as case law even says, that's why the cases are usually tried together, to figure out the truth and let fingers be pointed and let the jury sort through that. But here we don't see a finger pointing, but we do see like you said, the distance, a little separation out to say, hey, we're not on the same team. We're sitting at the same table. We're in the same trial, but we are not on the same team.